something like that. Just want the set to look good, you know. All right. Welcome back, everybody. Welcome back. Thank you for coming back for a second taste of our deep dive. Trying to say deep dive. Our deep dive into the model rules of professional conduct. You know me, I'm Patrick John McGinley. I'm your friendly neighborhood bar grievance defense attorney defending my fellow members of the Florida Bar and the District of Columbia Bar against bar grievances, ethics investigations, rendering ethics opinions, doing whatever I can to help my fellow Florida and DC lawyers to get these investigations behind them and back in the game of defending clients and providing justice where justice is needed. God bless justice. God bless you. Glad to see you back again. As promised, this lecture talks about legal services and the independence of the profession. That theme is going to encompass a couple of rules from two separate chapters of the ABA Model Rules of Professional Conduct. Of course, if you plan on taking the MPRE or an exam such as a bar exam, you're going to want to know the model rules. When you practice law, however, you're going to want to know the rules of your particular jurisdiction. For example, in Florida, we've got the rules regulating the Florida Bar. In DC, we have separate rules. Neither one of those are exactly the same as the model rules. But the model rules were the model for most states' rules. California excluded, I understand, but not a Californian, so don't quote me on that. But here we'll focus on the ABA model rules because that's helpful in passing the multi-state professional responsibility exam. And also we'll point out some differences that are relevant. But in our theme of legal services and independence of the profession, we're going to draw from two separate chapters of the ABA model rules. First, we'll draw from chapter 5. That one is called Law Firms and Associations. And there we're going to look primarily at Rule 5.3, Rule 5.4, and Rule 5.5. Rule 5.3 talks about responsibilities regarding getting assistance and having assistants that are not lawyers. Rule 5.4 is going to talk about the professional independence of you, the lawyer. And Rule 5.5 is going to talk about two slightly disparate topics, but it's certainly related. It's going to talk about the unauthorized practice of law, and it's going to talk about the multi-jurisdictional practice of law. Today's presentation focuses on the former more than the latter. We focused primarily in today's presentation on the topic of the unauthorized practice of law as covered in Rule 5.5. So that's what we're going to focus on from Chapter 5 of the model rules. We're also going to focus a wee bit on Chapter 7 because of the overlap there. Primarily, we're going to look at Rule 7.1. It's a short, pithy rule. I managed to make it even shorter in my slide. And that short rule talks about communication concerning a lawyer's services. So that's our roadmap. That is roughly what we're going to do today. By so doing, we probably won't need the full 90 minutes that you've allotted for this particular presentation. Now, if you promise not to tell anyone, then I'll finish in less than 90 minutes. But you have to promise not to tell. I can't hear you. Okay. Thanks for having my back. All right. So let's begin with Model Rule 5.5, or more accurately, let's begin by dancing around Model Rule 5.5. And what do I mean by that? Well, Model Rule 5.5 talks about the unauthorized practice of law. And as I'll cover in greater detail in just a moment, that is well said. Often we hear it called the unlicensed practice of law. That is not well said. It is far better to use the phrase unauthorized practice of law. And you'll see what I mean as we get into Model Rule 5.5. But Model Rule 5.5 is our launching point to answer this question. What is and what is not the practice of law? Stated somewhat differently, how do we define the practice of law? What we mean by that question is the thing being done a thing that we call the practice of law? Now, I'm standing in a courtroom representing a client, cross-examining a witness in front of a judge and a jury. Hey, that's the practice of law. Can't we all agree on that? Yeah. How about I'm adjusting a claim for the insurance company, deciding what should be paid and at how much? Is that the practice of law? Oh, lawyer, it's easy for you to say, yeah, that's the practice of law. But, lawyer, would you give the same answer if you were a licensed claims adjuster employed by the insurance company and licensed by the state to do that kind of work as the insurance company's employee? So the question then, what is and what is not the practice of law, I dare to suggest, might not be so simple to answer. A great illustration of exactly how states answer that question comes from an old 1970s decision from the great state of Florida. And it's a decision, no matter what state you're studying in, you're going to have to dust off the old Southern Second over here, and you're going to have to pull volume 355. You're going to have to turn over here. You youngins in the audience, do you recognize what this is? This is what Westlaw and Lexis and Find Case and Google Scholar were before there was such a thing as Westlaw and Lexis and Find Case and Google Scholar. This is the official reporter system. This is the Southern Reporter. And we're looking here at this particular case. Can you read it? Hey, maybe the slide's a little bit easier to read. We're looking at Florida Bar versus Brumbaugh, or you might just want to call it the Maryland Secretarial Service case, because that is certainly what the case is all about. It's all about Maryland and her Secretarial Service. So let's take a look at the opinion and see what I mean. Now, in this case, our good friends, the Florida Bar Council, they have filed a petition. They are charging Maryland Brumbaugh with engaging in the unauthorized practice of law. They are asking the Supreme Court of Florida, they're the ones with jurisdiction over such issues, to enter a permanent injunction prohibiting Maryland from further engaging in these allegedly unlawful acts. And it is not an exaggeration to say unlawful here in the state of Florida. It's not an exaggeration in most states and jurisdictions. If you practice law without a license in the state of Florida, you are violating your Florida statute, a criminal statute. Likewise, in most jurisdictions, there is a criminal law making it a crime to practice law without a license. So the question of what is and what is not the practice of law is not necessarily an academic question to answer. It can be a matter of freedom or not freedom, jail or not jail. So the question then is, what is it that Maryland Brumbaugh and Maryland Secretarial Service allegedly is doing, which then allegedly is the practice of law? The opinion reads, Respondent Maryland Brumbaugh is not and has never been a member of the Florida Bar and is therefore not licensed to practice law in the state. She is advertised in various newspapers as Maryland Secretarial Service, offering to perform typing services for do-it-yourself divorces, wills, resumes, and bankruptcies. The Florida Bar alleges that she performed unauthorized legal services by preparing for her customers those legal documents necessary in an uncontested dissolution of marriage proceeding, and by advising her customers as to the cost involved and the procedures which should be followed in order to obtain a dissolution of marriage. For this service, Ms. Brumbaugh charges a fee, get ready, of $50. Okay, granted, this is 1978. But still, $50 for your uncontested divorce? Anybody within the sound of my voice willing to finish an uncontested divorce for just $50? Didn't think so. Pretty darn cheap, whether 1978 or today. The opinion then says, of course, we must determine whether the Florida bar has presented sufficient evidence in the record before us to prove that the respondent has engaged in the unauthorized practice of law. So in other words, this case, Florida Bar versus Brumbaugh, is going to answer our question for us. You remember our question? What is and what is not the practice of law? Now, they quote first from a 1962 opinion of their own. Florida Supreme Court is quoting from a 1962 opinion of Florida Supreme Court, but they won't end their analysis there. They will consider other opinions from other states. But first, the 1962 Florida Supreme Court of State versus Sperry says this: the reason for prohibiting the practice of law by those who have not been examined and found qualified to practice is frequently misunderstood. It is not done to aid or protect the members of the legal profession, either in creating or maintaining a monopoly or closed shop. It is done to protect the public from being advised and represented in legal matters by unqualified persons over whom the judicial department can exercise little, if any, control in the matter of infractions of the code of conduct which, in the public interest, lawyers are bound to serve. Wow. We lawyers, we sound so great, don't we? It's not that we want a monopoly. No. It's all to protect the public, says State versus Sperry, 147 2nd 567, Florida Supreme Court, 1962. The United States Supreme Court, according to Florida Bar versus Brumbaugh, has recently decided issues which may drastically change the practice of law throughout the country, especially with regards to advertising and price competition among attorneys. What do they cite there? Same Supreme Court of the United States case I mentioned in our last presentation, Bates versus State Bar of Arizona. In addition, the Supreme Court has affirmed the fundamental constitutional right of all persons to represent themselves in court proceedings. What does Supreme Court of Florida cite to for that? You know, Ferretta versus California, SCOTUS's 1975 decision. In Ferretta, the Supreme Court of the United States emphasized that an attorney is merely an assistant who helps a citizen protect his legal rights and present his case to the courts. A person should not be forced to have an attorney. Sounds pretty helpful to Ms. Brumbaugh so far, right? Look, she wants $50. In return, she's going to help you with the forms. Is that the practice of law? Is it not? With regard to the charges made against Marilyn Brumbaugh, this court appointed a referee to receive evidence and to make findings of facts, conclusions of law, and recommendations. What did the referee find? The referee found that respondent, Ms. Brumbaugh, under the guise of secretarial or typing services, prepares for a fee all papers deemed by her. That's the kicker here. Did you hear that part? I'll read it to you again in case you didn't hear it. Prepares for a fee all papers deemed by her. Deemed by her. That's the kicker part. So, what if there are forms? Can I sell them? Sure. Is that the practice of law? No. What if I decide what forms you need? That, my friends, that is the practice of law. Which part? The selling the forms? No. The me deciding for you what forms you need. That is the practice of law. The opinion goes on. As well as detailed instructions as to how the suit should be filed, notice served, hearing set, trial concluded, and the final decree secured. The referee also found that in one instance, respondent prepared a quitclaim deed in reference to the marital property of the parties. The referee determined that respondent's contention that she merely operates a typing service is rebutted by numerous facts and evidence. Miss Bumbraw, remember, as you listen to these facts, remember, the kicker was deemed by her. The practice of law part was deemed by her. Listen to these facts with an ear toward deemed by her. Here are the facts. Miss Bumbraw has no blank forms either to sell or to fill out. Rather, she types up the documents for her customers after they have asked her to prepare a petition or an entire set of dissolution of marriage papers. Prior to typing up the papers, respondent asks her customers whether child support, custody, or alimony is involved. Respondent has 4 sets of dissolution of marriage papers, and she chooses, that's Miss Bumbraw who's choosing, and she chooses which set is appropriate for the particular customer. She then types out those papers, filling in the blank spaces with the appropriate information. Respondent instructs her customers how the papers are to be signed, where they're to be filed, and how the customer should arrange for a final hearing. Okay, you listen to those facts, right? You listen to those facts with an ear toward deemed by her. Can I sell blank forms? Is that the practice of law? Yes, I can sell blank forms. No, it's not the practice of law. If you hand me back your choice of blank forms, can I type in your answers? Yes. Is that the practice of law? No. So where did Miss Bumbraw cross the line? Where did she go too far? Or stated somewhat differently, here's my question again. What is and what is not the practice of law here? The practice of law part was the deemed by her. I can offer forms for sale. I can describe when individuals use different sets of forms. What Miss Bumbraw did was above and beyond all that. You only got to buy the forms that were deemed by her to be necessary under your facts. She listened to your facts, came to a legal conclusion, told you to use these forms and don't use those forms. Deemed by her. That is what made Maryland's secretarial service the practice of law. The opinion reads, the Florida Bar argues that the above activities of respondent violate the rulings of this court in the Florida Bar versus American Legal and Business Forms and the Florida Bar versus Stupica. Oh, this is interesting. Miss Bumbraw is representing herself in the proceedings before this court. Maybe it's just selfish on my part, because I have represented non-lawyers who are being pursued by the Florida Bar allegedly for the unauthorized practice of law. So maybe it's just selfish on my part, but I really think if you're alleged to be a non-lawyer who's practicing law, you really shouldn't go at it pro se. If you do a bad job and you lose, well, then you're going to be found guilty. If you do a good job and you're winning, isn't the judge going to say, hey, he or she sure looks like a lawyer here, right? You don't want them to think that you know how to practice law, that you've got experience in it, right? Anyway, I digress. Ms. Bumbraw represented herself in the proceedings. Florida bars arguing that these activities are the practice of law. They're citing the two prior decisions. In those decisions, the opinion reads, we held that it is lawful to sell to the public printed legal forms, provided they do not carry with them what purports to be instructions on how to fill out such forms or how to use them. We stated that legal advice is inextricably involved in the filling out and advice as to how to use such legal forms. And therein lies the danger of injury or damage to the public if not properly performed in accordance with law. Deemed by her. Remember, that's the attitude, that's the mental picture. That's how we're viewing these facts. Here, we can sell forms. The forms can have instructions. The problem is when we cross the line from blank forms with generalized instructions to legal conclusions and legal advice. In Stupica, remember that case earlier, that was the 1960s Florida Supreme Court decision that this 1978 Florida Supreme Court decision began by citing. In Stupica, this court rejected the rationale of the New York courts in New York County Lawyers Association versus Dacey, which held that the publication of forms and instructions on their use does not constitute the unauthorized practice of law if these instructions are addressed to the public in general rather than to a specific individual legal problem. Now, New York County Lawyers Association versus Dacey, that's the general rule. The general rule is that the publication of forms and instructions on their use does not constitute the unauthorized practice of law if these instructions are addressed to the public in general rather than to a specific individual legal problem. But in Florida, Florida Supreme Court in this 1978 decision of Florida Bar versus Bumbraw is saying that they're adopting a slightly more restrictive definition. The court in Dacey stated that the possibility that the principles or rules set forth in the text may be accepted by a particular reader as a solution to his problem does not mean that the publisher is practicing law. Again, that's the rejected New York opinion, but it is the general rule. Other states have adopted the principle of law set forth in Dacey. Yeah, that's what I'm saying. Holding that the sale of legal forms with instructions for their use does not constitute unauthorized practice of law. There they cite to State Bar of Michigan versus Kramer, Oregon State Bar versus Gilchrist. However, look how Supreme Court of Florida distinguishes the general rule. However, these courts have prohibited all personal contact between the service providing such forms and the customer. Oh, social distancing. Hey, they're ahead of their time, huh? Is it too soon to joke about things like that? I mean, no offense. These courts have prohibited all personal contact between the service providing such forms and the customer in the nature of consultation, explanation, recommendation, advice, or other assistance in selecting particular forms, in filling out any part of the forms, suggesting or advising how the form should be used in solving the particular problems. Remember, chosen by her. Listen to the things that are a problem. Listen here. It becomes the practice of law when there's assistance in selecting particular forms, in filling out any part of the form, suggesting or advising how the form should be used in solving a particular problem. All right. Here's a good one for you. I love writing and publishing law books. Can you write and publish a law book if you're not a lawyer? Or would doing so be the practice of law? Answer, you can. It's not the practice of law. Chosen by her. Okay? Non-lawyer writes a law book. It gets printed. It's on the bookstore shelf for folks to buy. It's on the Amazon.com website and other websites for people to order. Not the practice of law. Meet with someone who opens the book and tells you your answers on this page. That's the practice of law. Are you starting to get a feel for the correct answer to this question? What is and what is not the practice of law? Although persons not licensed as attorneys are prohibited from practicing law within this state, says the Florida Supreme Court in Florida Bar versus Bumbraw, it is somewhat difficult to define exactly what constitutes the practice of law in all instances. This court has previously stated that if the giving of such advice and performance of such services affect important rights of a person under the law, and if the reasonable protection of the rights and property of those advised and served requires that the person giving such advice possess legal skill and a knowledge of the law greater than that possessed by the average citizen, then the giving of such advice and the performance of such services by one for another as a course of conduct constitute the practice of law. Ooh, makes you want to get out your highlighter, right? There it is. There's my rule of law, right? Oh, there it is. I got my definition, right? It's only one problem. What does it say? I mean, seriously, what does it say? Yeah, we read it. It's kind of like when a politician gets asked a question on the news that they didn't have talking points for, and words come out of their mouth for a good long time. And, well, there were a lot of words, there was a lot of time. I guess they answered the question, right? But they didn't. You've seen politicians do that. By analogy, isn't that a fair analogy? Isn't that kind of what happened here? Listen to this definition. If the giving of such advice and performance of such services affect important rights of a person under the law, and if the reasonable protection of the rights and property of those advised and served requires that the persons giving such advice possess legal skill and a knowledge of the law greater than that possessed by the average citizen, then the giving of such advice and the performance of such services by one for another as a course of conduct constitute the practice of law. All right. But how do I apply that? Here's how I suggest it be applied. Chosen by her. Did I mention that phrase already? Like a dozen times, right? Chosen by her. That's the glasses through which you should examine the facts in order to determine whether those facts constitute the unauthorized practice of law. That's what I suggest. Want a big, long, mumbo-jumbo definition of the practice of law? There it is. Read it to you twice already. Want a more practical, more useful definition? Chosen by her. If I'm choosing the remedy, if I'm choosing the path, if I'm choosing what to fill in the blanks, if I'm choosing one set of forms over another, now I've crossed the line. Now I'm practicing law. All right, it's not as wordy, it's not as technically articulate as what we've got here. But I dare say, chosen by her is a far more useful definition. And if you're taking the multi-state professional responsibility examination, it's a lot easier to remember chosen by her, and it's a lot more fruitful to apply that standard to the fact pattern you see and get yourself the right answer. Now, after this more elaborate, more detailed, more eloquent version of chosen by her, the court then apologizes for it. Here's what they say. This definition is broad and is given content by this court only as it applies to specific circumstances of each case. We agree that, quote, any attempt to formulate a lasting, all-encompassing definition of practice of law is doomed to failure for the reason that under our system of jurisprudence, such practice must necessarily change with the ever-changing business and social order, which they quote from State Bar of Michigan versus Kramer. Wait a minute, were y'all just trying to distinguish away that Michigan case a few paragraphs ago? And now you're stealing its apology for the fact that this unwieldy, wordy definition of the practice of law, and you're apologizing for that. Okay. It then goes on after the apology. In determining whether a particular act constitutes a practice of law, our primary goal is the protection of the public. Hey, good for you. Yeah, we began with that, how, this monopoly of ours as lawyers, that wasn't our goal. Monopoly, no. Monopoly, who? That wasn't our goal. Protection of the public. Yeah, that's it. However, any limitations on the free practice of law by all persons necessarily affects important constitutional rights. Our decision here certainly affects constitutional rights of Marilyn Brumbaugh to pursue a lawful occupation or business. Our decision also affects respondents' First Amendment rights to speak and print what she chooses. In addition, her customers and potential customers have the constitutional right of self-representation, see Ferretta, and the right of privacy inherent in the marriage relationship. What they quoted there, I will not read out loud. All citizens in our state are also guaranteed access to our courts by Article 1, Section 21 of Florida's Constitution. Article 1, Section 21. Yes, Kluger versus White tells us that is the right of access to courts under Florida's Constitution. Although it is not necessary for us to provide affirmative assistance in order to ensure meaningful access to the courts to our citizens, it is necessary for us to do so for those incarcerated in our state prison system. We should not place any unnecessary restrictions upon that right. Okay. So this opinion goes on in apologizing for the fact that their very wordy definition of what is and what is not the practice of law, essentially their definition boils down to, we'll know it when we see it. What's the problem with the definition that boils down to, we'll know it when we see it? Problem is you got to show it to them to find out. Or stated somewhat differently, if you have a legal standard that essentially says you'll find out the answer after you litigate, the only way to find out the answer is to litigate. Here's the problem for the Marilyn Brumbaughs of this world. Knowing that litigating decides not only whether you stay in business, but whether or not you go to jail. Do you really want to only find out after you litigate? Or wouldn't you like to know up front? That's the problem with this dusty old reporter, and why I say this definition is something you should just throw away. What then, and what is not the practice of law? Well, the definition is flexible enough to cover whatever it is the decider wants to cover. In your jurisdiction, maybe the decider, I borrowed that word from George W. Bush. Had they put that in the dictionary yet? In your jurisdiction, the decider might be your state's high court. Hopefully it's your state's legislature. It's going to vary from state to state. In 1978, when Florida Bar versus Brumbaugh came out to much acclaim and widespread adoption, I guess they weren't worried about them internets. Have you heard of this? Internets. Apparently the computers can talk to one another. You aware? Of course you are. But they weren't in 1978. Cross-border practice of law, it existed back then too. But gosh, it's almost unavoidable now, isn't it? So what's the practice of law? What's not the practice of law? It's going to vary state by state. At least my definition, as inartful as it is, yields you an answer that's going to be correct not only in the MPRE, but on any state in the United States or territory or the District of Columbia that you happen to find yourself in. At least with my definition, as awkward as it is, you can know beforehand whether you're going to go to jail and get your business shut down before you actually do it. In my opinion, that makes it a better definition. But hey, who am I? Opinions are like noses. Everybody has one. So anyway, that was mine. All right, then. So now that we have not answered this question, since Nobody has. And now that we have done a good job of dancing around Model Rule 5.5, how do we practice law without passing a bar exam? Are there ways? Well, here's one option. Pro hoc vice. Have you heard of it? That means you're admitted somewhere else, but not here. And you're asking here for permission to practice law here. Pro hoc vice typically is for a given case. So you're not admitted pro hoc vice for the state. You're admitted for that case in the state. Could be for a transaction also. Could be for a tribunal. But it's for a particular instance. It's not a broad license to practice law throughout that state. It's permission to practice in that particular issue, in that particular lawsuit, in that particular claim. Another one, reciprocal admission. Not every state has that. No, can't see the R. It's because of the light. Now you can see the R, but you can't see right side of my face. Anyway, reciprocal admission. That would mean that if you're a member of a bar somewhere else, we'll take your money, we'll check your background, assuming we like your background, assuming we like your money, then you can have a license here too. Not every state grants reciprocal admission. Missing a light. There we go. Indeed, here in the state of Florida, where I'm licensed, and in the District of Columbia, where I'm also licensed, they're kind of like polar opposites, huh? DC grants reciprocal to just about everybody in the United States of America. State of Florida grants reciprocal admission to nobody. Wisconsin's diploma privilege. Have you heard about this? I don't know all the details, but apparently if you are in Wisconsin and a graduate of an ABA-approved law school that's also in Wisconsin, then the privilege of having received such a diploma means you now can practice law in Wisconsin. Forget about the bar exam. Not sure that there's any other state that does that. Is that all? Well, how about this one? This is a long hypothetical slide. Don't worry if you can't read it all, I'll read it to you. It's about Johnny. I made Johnny up, but they're very realistic facts. Now, Johnny, he never went to law school. He wants to call himself a patent agent, but there's a problem with that. See, there's an exam. He took the exam, and he flunked the patent bar exam. That's the name of the exam, patent bar. And Johnny flunked it. It's given by the United States Patent and Trademark Office. That's the office that gave Johnny his F and did not give Johnny the title of patent agent, because you only get that title on that instance if he had passed, and he did not. So he's got to follow another career path, but his interests remain the same. Johnny gets a job with the United States Patent and Trademark Office. They hire him as a patent examiner. Cool gig. I knew a guy who had it. 4 years later, Johnny quits his patent examiner job at the USPTO, and then following the rules for former patent examiners that you can find in 37 CFR section 11.8, that's the Code of Federal Regulations, Johnny obtains the title patent agent by following 37 CFR section 11.8, the same title that he would have earned 4 years earlier if he hadn't flunked the patent bar exam. With title in hand and on his business card, Johnny moves to Florida, opens his own office, advertises, gives legal advice to patent applicants, drafts up patent applications for those applicants, meets with and argues with the USPTO over denials of those applications, etc., etc. Chosen by him. Can the Florida bar shut down Johnny's office? Johnny's not a member of the Florida bar. Answer's no. Why is the answer no? Is Johnny practicing law? I think by any definition, Johnny is practicing law. Does Johnny have a license from the Florida bar or from any state to practice law? No. Johnny does not have a license from Florida or any state to practice law. Wait a minute. He's practicing law without a license. Isn't that the unlicensed practice of law? Well, maybe, but that's an inartful way to phrase the issue, as I mentioned at the beginning of our broadcast. The issue is not whether someone is practicing the unlicensed practice of law. The issue is whether an individual is practicing the unauthorized practice of law. Under 37 CFR section 11.8, Johnny's activities are authorized under federal law. Therefore, Johnny is engaged in the authorized practice of law. He is not engaged in the unauthorized practice of law. The Florida bar cannot shut down Johnny's office, and that answer will remain true for so long as Johnny's activities remain within the authorization given to him by the title of patent agent as earned under 37 CFR section 11.8. Under our federalism system, federal law most often and almost always preempts state law. This is an example of federal preemption. Here, what's being preempted is the Florida Constitution, which says that only the Supreme Court of Florida can authorize the practice of law in Florida. Here, not for any type of law, not for any issue, but for these patent agent jobs described here, Johnny has authorization from the federal government. And that authorization preempts the lack of authorization from the state government. Does that mean Johnny can do divorces as a patent agent? No. Does that mean Johnny can do small claims court, personal injury protection cases as a patent agent? No. But look at all that Johnny can do. Move to Florida, open his own office, advertise, give legal advice to patent applicants, draw up patent applications, meet with the USPTO, argue with the USPTO over denials. Sounds a lot like the practice of law because it is. But it is the authorized practice of law. It's the authorization that makes the difference. Let's take a look at Model Rule 5.3, shall we? I sure did dance around 5.5. But let's look at Model Rule 5.3. 5.3 talks about responsibilities regarding non-lawyer assistants. Or should it read assistants? You know, it used to read assistants. I think it was around August of the year 2012 that the American Bar Association, in their wisdom, decided to amend their own rule to insert the typo, the typographical error, to replace assistants with assistants. Not a lot of groups would amend their own rule to insert a typo. That's the ABA for you. All right. Responsibilities regarding non-lawyer assistants. What are we talking about here? We're talking about someone who's employed, retained by, or associated with a lawyer who's not a lawyer. So we're talking about a lawyer getting an assistant. We're talking about a lawyer hiring a paralegal, hiring a secretary, hiring a law clerk, hiring a file clerk, hiring a case manager. I've met individuals that introduce themselves. Hi, I'm a case manager. It's cool. Respectable work. I respect that. Hiring an assistant case manager. Hiring an office manager. Hiring an HR person. Hey, hiring a compliance officer to give them ethics opinions. I'm a lawyer, though. Yeah. So lawyers need employees. We're talking about the assistants they hire, or if you prefer the typo, the assistants they hire. Anyway, so A partner and a lawyer who individually or together with other lawyers possesses comparable management authority, they got to make reasonable efforts that the firm has things in effect that mean these assistants are going to provide assistance that is not in violation of the rules regulating the Florida bar. Specifically, the lawyer who's got direct supervisory authority over the non-lawyer, that lawyer has to make reasonable efforts to ensure that the non-lawyer's conduct doesn't violate the lawyer's own professional obligations. That's a paraphrase of how Model Rule 5.3 is written. Allow me to change the perspective a little bit, because in so doing, I'm going to reveal to you how it usually appears in an MPRE question, a multi-state professional responsibility exam. The lawyer becomes responsible if the non-lawyer breaks the rules. With certain exceptions. But the first thing we need to know to avoid the lawyer being held responsible for the wrongful professional responsibility violations of the non-lawyer is that if you're the direct supervisor, you got to be able to show that you made these reasonable efforts to ensure that the non-lawyer is going to act properly. If you're a partner or somebody else has comparable managerial authority over the firm, likewise, you're going to have to show that you made reasonable efforts and that you put in effect measures giving reasonable assurance that these violations aren't going to happen. Now, the lawyer's going to be held responsible for conduct of the non-lawyer that violates the rules of professional conduct if either one of these two things is true. Option 1, the lawyer orders or ratifies the wrongful conduct. That's a question of timing, right? If you tell them before they do it to do it, then you've ordered it. If you find out after they did it, and you're, all right, sweep it under the rug, then you ratified it. Either way, regardless of the timing, if you order or ratify, you're going to be held responsible for the non-lawyer's violation of the rule of professional conduct. That's option 1. Option 2. If the lawyer's a partner or has comparable managerial authority to a partner, or has direct supervisory authority, and knows of the conduct at a time where you could do something to mitigate the harm, and you don't do something to mitigate the harm, then you're held responsible. So now this option 2 is always after the fact, right? And it applies when you could do something after the fact, when the consequences can be avoided or mitigated, but you don't. That's how you become liable for the non-lawyer's violations of the rules of professional conduct under option 2. Now, notice there under option 1, didn't matter who you are. If you gave the order or afterward you ratified, doesn't matter if you're a partner or not, doesn't matter if you're a supervisor or not. So the case law uses a slang term that I don't hear much nowadays, runners. Runners. We're not talking about a marathon. We're not talking about an Olympics. The case law was talking about somebody who's a non-lawyer who would go get your cases for you and bring them in. Runners. There's a proper way to do that, and there's an improper way to do that. The improper way is any way that violates the rules of professional conduct. If your runner's out there violating the rules of professional conduct and you order them to do that, you're responsible under option 1. If your runner's out there and you're willfully blind, you're looking the other way, you don't know nothing. I know nothing. And the cases are coming in, and you're working the cases, and you're collecting the fees. You've ratified the behavior, and you're responsible under option 1. Doesn't matter who you are. Doesn't matter who you are. Option 2 matters who you are. It matters either in name or in effect. Name or effect, what do I mean? Name, if you're a partner. If you got that title, partner. Now, I understand there were some good old days. I've been practicing 24 years, and I never personally experienced these days. But I guess they existed, where if you had the title partner, that means you had equity. You had ownership. You had a stake in the equity and the ownership of the firm. Nowadays, more often than not, partner is a title, not an equity ownership. But if you've got that title, then you're eligible for being responsible for a non-lawyer's wrongful behavior under option 2. If you've got the title. The other way you can be one of the potential liable attorneys is if you had supervisory authority. Now, in a smaller firm, it's hard for any lawyer to say that they don't have supervisory authority. The larger the firm gets and the more documentation, like written partnership agreements that exist, the more likely it could be that you might have supervisory authority over ABC, but not over XYZ. So that can be a shield to prevent you from becoming one of the liable attorneys when a non-lawyer violates the rules of professional conduct. The comment, paragraph 2 of ABA Model Rule 5.3 tells us this. Lawyers generally employ assistants in their practice, including secretaries, investigators, law student interns, and paraprofessionals. Such assistants, whether employees or independent contractors, act for the lawyer in rendition of the lawyer's professional services. A lawyer must give such assistants appropriate instruction and supervision concerning the ethical aspects of their employment, particularly regarding the obligation not to disclose information relating to representation of the client, and should be responsible for their work product. The measures employed in supervising non-lawyers should take account of the fact that they do not have legal training and are not subject to professional discipline. They didn't go to law school, you did. There's things you learned in law school that they need to know. Whose job is it to teach them that? Yours. That's what the comment is saying. Let me draw your attention briefly to Model Rule 5.1. This talks about responsibilities of partners, managers, and supervisory lawyers. It says a partner in a law firm must make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. Likewise, in Rule 5.2, responsibilities of a subordinate lawyer, the subordinate lawyer is supposed to follow the rules himself. And then Rule 5.3 says that whether you're the partner or the subordinate lawyer, you might have assistants. And you got to make sure to tell those assistants about confidentiality, about the rules regulating your profession, so that they aren't violating them on your behalf. Returning back to Rule 5.1, its official comment, let me highlight this sentence from its paragraph 2. Policies and procedures that they recommend in order to have these reasonable efforts to make sure the non-lawyers are following the rules. Policies and procedures include those designed to detect and resolve conflicts of interest, identify dates by which actions must be taken in pending matters, account for client funds and property and ensure that inexperienced lawyers are properly supervised. Look, good for you. Your firm grows. You hire associates. You hire paralegals. You hire investigators. You hire case managers. You hire assistants to assist the case manager. You hire an assistant investigator to help the investigator. This is all wonderful, but you've also got to give them tools. Tools. There are deadlines in your cases. There's all kinds of off-the-shelf software. And personally, I don't use software. I use SaaS, software as a service. I use cloud-based. I use website subscription things instead of software. Use what you like, but use something. Use some tools that's going to help you detect and resolve conflicts of interest. It's going to help you identify dates by which actions must be taken. That's going to help you keep a calendar. It's going to help you keep a to-do list. It's going to help you keep a trust account. It's going to help you account for clients' funds and property. That's going to help you keep track of the lawyers and their continuing legal education requirements and know that they're going to these classes and what they're learning in these classes and teaching them yourself. These are things you've got to do as your law firm grows, as your practice grows, whether or not you're a managing partner. It's part of your professional responsibility. And if you neglect it, even though you never violated the rules of professional conduct, you might be held responsible for someone else's violation. So that's what Model Rule 5.3 is talking to you about. Model Rule 5.4, professional independence of the lawyer. Here, what we're talking about is that a lawyer needs to have independence. And why? Why? Because it's so cool? Well, yeah, that's good too. But it also serves the public interest. It's lawyer independence, in certain respects, helps to serve the public interest. And I mean no disrespect to my fellow members of the DC Bar when I say that. And I'll explain that comment in just a second. But serves the public interest. Let me show you here. The provisions of this rule, I'm reading from the official comment to Model Rule 5.4. The provisions of this rule express traditional limitations on sharing fees. That's the comment. I'll read you the rule. A lawyer or law firm shall not share legal fees with a non-lawyer. Sounds a bit greedy. And in a way it is. You know, everything has its limits. And indeed, even in the model rules, they have not one, not two, not three, but 4 exceptions right there in the rule. And in the District of Columbia rules, as I'll get to in a moment, broader exceptions. But hey, let's stick to the Model Rule 5.4 for now. A lawyer or law firm shall not share legal fees with a non-lawyer. What are the exceptions? One of the exceptions is you can share them with your employees in a proper way. What's the proper way? A retirement or profit sharing plan. Specifically, the rules say non-lawyer employees in a retirement plan or a profit sharing arrangement, that's okay, even though the plan is based in whole or in part on profits from legal fees. Okay. Under the model rule, don't interpret that too broadly. You can set up and get approved by the government a profit sharing plan under federal law. If you've done that, and that's how your non-lawyer employees are receiving the money, you're golden, you're fine. Don't read it so broadly as to say, well, you know, I'm going to give a 5% bonus, 5% of the fees I bring in to my employees. That way, they help me maximize my fees because their 5% goes up whenever the fee goes up. Wrong, wrong, wrong. No, no, no. That's not allowed. That violates the rule that a lawyer or law firm shall not share legal fees with a non-lawyer. So don't misread this exception so broadly. Don't misread it to say, oh, as long as it's an employee of yours, you can share the fee. No, that's not what it's saying. It's spelling out a very specific way to share with an employee, and only that way. That's one of the 4 options in the model rule. Second option, an agreement to pay after a lawyer's dead, to pay legal fees to the lawyer's estate or the beneficiaries of the estate. When's that often happen? Contingency cases. Imagine it. Lawyers worked for months, years, 2 years, 4 years, passes away, and then finally, after 4 years and 2 months, the lawyer's been dead for 2 months and the case finally settles. It's only fair, right? It's only fair. The lawyer is passed, but his estate and his heirs are here. Model rule provides an exception. A third exception in the model rule: when you're purchasing the law practice of a lawyer who's either deceased, disabled, or disappeared. 3 Ds there. How about that? Deceased, disabled, disappeared. The lawyer is either deceased, disabled, or disappeared, and you're buying that practice. You can pay that to the estate or other representative of the lawyer, even though that's the payment of legal fees. That is an exception in the rule. And the fourth exception is to help nonprofits to not have to keep lawyers on the payroll 24/7, not to have on-staff lawyers. The exception reads this way: a lawyer may share court-awarded legal fees with a nonprofit organization that employed, retained, or recommended employment of the lawyer in the matter. I'm quoting verbatim from Model Rule 5.4 sub A sub 4. So the lawyer can share what kind of fees? Court-awarded legal fees. Can share them with who? A nonprofit. Any nonprofit? No, the nonprofit who sent that particular case where the court awarded fees to that particular lawyer. That nonprofit you can share. So those are the 4 exceptions under Model Rule 5.4. There are also in Model Rule 5.4 restrictions upon equity ownership of a law firm. And under the Model Rule, if you're not a lawyer, then you don't own equity in a law firm, as the general rule. What are the exceptions? Let's discuss. First of all, a lawyer under the Model Rule 5.4 can't form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. So there might be parts of the partnership that aren't the practice of law. Maybe they're lobbying, for example. Maybe they're accounting, for example. Pick any non-practice of law example you want. If there's any percentage of the practice that is the practice of law, doesn't have to be 100%, doesn't have to be 99%, doesn't have to be 10%. Maybe it's 1%. Maybe it's 1/100%. If there's any practice of law involved in this partnership, then all the partners under the Model Rule all have to be lawyers. Now, that's true under the Model Rule. That's true under the rules regulating the Florida bar where I'm licensed. That is not true under the rules of professional conduct of the District of Columbia where I'm licensed. In DC, non-lawyers can join in a partnership with lawyers. For example, lobbyists. This may surprise you, but in the District of Columbia, there's more than one lobbyist. What? Yeah. Actually, there's quite a few lobbyists in the District of Columbia. Who knew, right? Your local congressman knows. I can guarantee that. Oh, congresswoman. Anyway, yeah. So different strokes for different folks. There's time and a place for everything under the sun. And that spirit of subsidiarity means that sometimes local problems require local solutions, and that what's good for one may not be good for all. It's an appropriate modification, very appropriate, that the DC Bar has made because of the circumstances of the District of Columbia. It's probably appropriate to make that modification in other places too. But to my knowledge, the District of Columbia is the only place where non-lawyers and lawyers can join into a partnership. Under the model rule, can't be done. It will be a violation of Rule 5.4 sub B. Now, 5.4 sub C says that a lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services. That is truly about the professional independence of the lawyer. Now, think about that. Are there times where the lawyer is being paid by someone they don't represent? Oh, yes, every day this happens. For example, those who are insured, those who have an insurance policy, and those who receive representation as one of the benefits of being insured. Do you drive a car? If you drive one, in most states, you have to have a bare minimum of auto insurance. And part of that policy in most states contains a duty to defend, which means insurance companies got to pay your lawyer to defend you. And many policies of insurance, for very many things, contain a duty to defend. So when the money's not coming from the client, the temptation is there to do what he or she holds the purse. He who holds the purse holds the power. Not for lawyers. For lawyers, the duty of loyalty goes to the client, regardless of who's paying the client's legal bills. That's what Model Rule 5.4 sub C means when it says a lawyer shall not permit a person who recommends, employs, or pays the lawyer to direct or regulate the lawyer's professional judgment. Where does this come into play? Well, it can be most difficult when it comes to the cost of the representation. Say it's in your client's best interest to take a deposition. And your favorite court reporter charges an appearance fee of $80. The insurance company only pays appearance fees up to $20. And they've got a list of other court reporters that are willing to accept a $20 appearance fee. Well, that's probably not a violation of your professional independent judgment. After all, every court reporter is sworn to accurately type the transcript unless you have some sneaking suspicion that the lower priced court reporter is going to violate those rules. Then it's probably okay to succumb to the insurance company's request to save the insurance company $60. But let's think of a more extreme example. You're convinced that your client should win the case, but can't win the case without the benefit of expert testimony from an independent medical examiner. The insurance company says we pay for independent medical examiners, but these IMEs, we only pay up to $800. And search as you will, because of the particular medical specialty, you can't find any doctor within any reasonable distance who won't do it for anything less than $2,000. What do? Do you not get the IME? No independent medical exam? When, in your professional judgment, it is necessary for your client's victory? What do? In such an instance, you've got to get that IME. And it may be true that your client's insurance benefits don't include full payment. You may have to have the difficult discussion with your client of saying, hey, cheapest I can get this done for is $2,000, and the most I can get reimbursed is $800. This doctor's not going to do the work unless somehow you come up with the $1,200. Difficult conversation to have. But you know what's even more difficult a conversation to have? To skip the IME because you didn't want to have that difficult conversation, to lose the case, to have your client file a grievance with the bar accusing you of letting your independent judgment be compromised by the person who is paying the bills. That's an even more difficult conversation to have. So do the right thing. Do the right thing. Rule 5.4 sub D talks about a lawyer shall not practice with or in the form of a professional corporation or association authorized to practice law for a profit if either one of these three things are true. First thing, if a non-lawyer owns any interest in it. Second thing, if a non-lawyer is a corporate director or officer in it. Third thing, if a non-lawyer has the right to direct or control it. Those three things are part of the model rule. Remember, there are exceptions, such as the District of Columbia. But speaking of the model rule, when it comes to the ownership, equity, and control of the law firm, it's got to be in the hands of lawyers, not non-lawyers. And why? Because we're trying to preserve the professional independence of the lawyer. The rule expresses traditional limitations, says the comment, on permitting a third party to direct or regulate the lawyer's professional judgment in rendering legal services of another. So this was tradition. This is how it was in days gone by that, despite my age, I am too young to remember. And they are held fast with a litany of exceptions in the model rule, and held not so fast with broader and broader exceptions, depending on what jurisdiction you happen to go to. That's the professional independence of a lawyer under Model Rule 5.4. A quick look now at Model Rule 1.7 before we sign off from this broadcast. I'm sorry, Model Rule 7.1. I said 1.7. I misspoke. I meant Model Rule 7.1. That's the rule we're going to take a quick look at before we sign off from this broadcast. Model Rule 7.1 talks about information about legal services. It's a very short rule, but I shortened it even more here with the ellipses. A lawyer shall not make a communication about the lawyer or the lawyer's services that contains a material misrepresentation of fact or law or omits a fact necessary to make the statement considered as a whole not material and misleading. In today's day and age, with so many prior restraints upon the speech of lawyers, specifically so many jurisdictions requiring that advertisements be filed in advance and approved by the jurisdiction that regulates the lawyer, maybe this isn't such a concern for such things. In most jurisdictions, something like a letterhead or business card need not be previously filed, so there's no prior restraint upon your free speech on letterhead and business cards. When it comes to radio and TV advertising, print advertisements, a lot of prior restraint upon that type of speech. When it comes to websites, usually not, depends on the jurisdiction. So you can run afoul of these things inadvertently when you're typing up your letterhead or your business card. You can't make a material misrepresentation. That's obvious. A little bit harder is not to omit a fact necessary to make the statement considered as a whole not materially misleading. And this is where things like the National Conference of Bar Examiners and their multi-state professional responsibility exam love to throw you a curveball. I'll make up a hypothetical. It's far-fetched, but not far-fetched when it comes to the MPRE. Far-fetched when it comes to reality, but not when it comes to that multi-state professional bar exam. Imagine, if you will, a large tract of land used to all be orange groves, but now a developer's put in a couple hundred homes and has taken the time to incorporate this area into a town. Maybe it's called Town of Orange Grove. There in the town of Orange Grove, along with the houses, there's a couple strip malls, a couple of office complexes. Finally, the first lawyer puts an office in Grovetown, Orangetown. What did I call this hypothetical town? Orangetown. In Orangetown. So, puts on his letterhead, finest lawyer in Orangetown, because he's the only one. Get it? only lawyer in Orangetown. So he puts finest lawyer in Orangetown. That would be a violation of facts necessary to make the statement considered as a whole not materially misleading. He neglected to mention he's the only lawyer in Orangetown. Also, I guess you could argue he neglected to mention he's also the worst lawyer in Orangetown. Since he's the only lawyer there, not only is he the best, he's also the worst, right? Okay, a little far-fetched for reality. But they love on the MPRE to do that. So it sounds like such a mundane statement. But there's a material fact, or there's an omission of a fact necessary to make the statement considered as a whole not misleading. So something to watch out for there. Anyway, I've enjoyed yet another presentation. Hope you'll come back for another one. This one ended a bit early, but I think we were thorough covering everything. I wish you well. May God continue to bless us all. And until next time, stay well.